All right. Good afternoon, everyone. This is Curt, and welcome to another edition of Fire Law Roundup today for May 30th, 2022. Brad, go
Memorial
ahead and
Day.
take us away. And
Yeah, first, I don't know if we say happy Memorial Day, but it's certainly a very solemn and respectful Memorial Day. And thank you to all the veterans and those who continue to serve. Obviously from Curt and I, we really, and everyone else, appreciate your service and past service. Okay, let's do a couple of simple ones. And this is all kind of simple, but man, the longer you do this, you're just like, does anyone ever listen to this stuff? Because they keep doing it. So just a quick one. And there's no conclusions you can draw from this. In Sacramento, a fire chief was terminated by the city. He chose not to resign, and I guess chose to be terminated. We could have a whole bunch of management questions if that's good for your career, to get in it with your employer, but different issue. I think the city tacitly claimed it was a management style difference. That's a real good way to do it. And to be, I think somewhat respectful on my belief. But the chief said in an interview that he joined under a lack of accountability in the city, and he felt like he was making some progress. We don't really know what the issue is, so it's short because there's not much to discuss other than the news reporter actually found that the chief who resigned or was terminated in 2020 was the subject of a lawsuit. He was one of I shouldn't say the subject. He was named as a defendant in a lawsuit, which involved discrimination and retaliation. And he was one of other defendants. The city pretty much didn't comment on the termination, so we really don't know anything about it other than this. But I think, and there's so many various facts that you could guess or put in, but I would use this more as to the chiefs, when you get into a fight with your municipality, is it worth resigning and going away quietly and finding another job? Or, is it worth having this fight? And I'm not commenting that it is or is not worth it. We don't know anything about the truth other than what, saw on the news.
yeah, I did have someone reach out to me and said they couldn't really talk about it, but they said there's a lot more in this case. So,
Always.
Yeah, there always is, and there's always two sides too. So I get that, and but that the person stated that this chief was very highly respected in the organization, which is not really what the media suggested. The media suggested he had some problems, and he put in a full career in Philadelphia, which is that's a metro fire department.
Oh yeah,
and I know many of the chiefs from Philadelphia and currently in Philadelphia, and I've got the utmost respect. Very squared away folks, and so he apparently traveled across the country, which is always, I've had to negotiate contracts for chiefs, and it's always a little bit risky especially when you're uprooting your family, you're moving not just down the street, but you're moving across the country. And then you're always concerned about your reputation for your next job. And there is a little bit of a science behind trying to negotiate those exit strategies when you find yourself in that kind of a situation. But there may be more here than what meets the eye. And that suit, I did get a copy of that lawsuit you're referencing, and it's really kind of somebody's job got reclassified, and they were upset. They had previously filed complaints and discrimination, and they were fired. They got rehired, and now they're filing a second round of lawsuits. And that one, the chief got named. So whether it's whether there's some fire behind the smoke. I know that chiefs all across the country are under attack. And it's one of the most difficult positions to be in is to be a fire chief in a community, particularly coming from outside, particularly coming not even from California, where the California Fire Service
very much its own.
It is in many respects, and they've got to be able to do it all. You're fighting a high-rise fire 1 minute, and the next you're out in a major wildland fire, and then you're dealing with an earthquake, right?
Yeah.
So they've got a lot to contend with. And so to come from the East Coast over and face that, I think is a challenge in and of itself. So I don't know. It'll be interesting to see. But you know, that fact pattern, you know, I plan to do some research into what's leading to litigation in the fire service. And as I was reading this and the fact pattern, the fact that you've got somebody that's been complaining in the past about different things, now they're complaining. Yeah, it just lends itself to some of the theories that I'm working on. But it's a case we'll be following, no doubt.
Right. And by the way, my theory is you were offended, right? Your reputation, you impugned my reputation by firing me or asking me to resign. The problem is I personally believe these fights picked by the chief who's offended is short-sighted. I'm not commenting on this one because I don't know, but right, because I think you do yourself more harm not leaving quietly and gracefully and maybe with some negotiated separation pay and whatever, and agreement if somebody calls you what a pre-written statement. But you know, if people make their own choices, who knows? Right. But I'm betting it's you were offended by how dare you do that to me, so I want to sue you. But a lot of places don't want to hire somebody who's, you know, been a chief and then sued their municipality. So I don't know whether it has value or not, but not commenting on him specifically, certainly.
Yeah.
Okay, let's head to San Francisco. This is another Bill of Rights case, sort of. Curt, let me ask you first, because we had another one. These come up one every 4 or 5 times. Do you know about how many states have a formal firefighter Bill of Rights?
I think it's 7. But see, some of the states have a law that it's not termed a firefighter Bill of Rights. You know, for example, Indiana has some laws. Illinois doesn't really, I don't think they call it a Bill of Rights, but 7, I would say between 7 and 8, 9, depending on how you define Bill of Rights.
Okay. And as I read this, I realized, you know, New York has one of those. It's just how firefighters are disciplined in New York, but it's effectively this, not as well, in some senses detailed, some not. But here's what it is, and this is just a suit. So this is just for discussion purposes. I'll give you my couple comments. But we're in San Francisco, and there's a firefighter who was terminated in 2020. He filed a lawsuit. He alleges that the city failed to comply with the California Firefighter Procedural Bill of Rights, and that word's important. And he claims he was denied a fair hearing. Now, he was fired for, from what we understand at least, for failing to meet requirements of the job. And we'll get back to what that was in a second, but basically the chief has alleged that the firefighter was unable to perform an essential skill for a firefighter, charged him with violating the rules and regulations. First, they charge him with inattention to duty. I don't totally know what that means in this case. And then they charge him with incompetence, which makes sense to me if he can't meet an essential skill. In any event, the underlying charges in some sense are not as relevant as the procedure. So he was given a hearing. He then appeals, not to a court yet, but basically an internal administrative appeal process. It's like the appeal of the hearing, and the appeal upheld the results of the hearing, being termination. So now he then sues in the lowest court in California. And generally what he you know, it's a long suit where he goes through a whole bunch of violations, but his primary violation is procedural, and I'll explain it. And again, this is not such a widespread issue, but there is a point I want to make at the end of this, which I will. So, because this only affects, as we're talking, 7 states and some others with similar, although I will tell you probably every state has a procedural due process requirement, whether in statute or case law or constitution, right? There's probably always some sort of
federal constitution can touch on it. But this goes beyond what the Constitution requires.
Oh, of course, of course. Yeah. So here, what the firefighter is saying is he didn't get a fair hearing for a number of reasons before the administrative law judge. And he said he should have gotten what's called a de novo review, which means review all the facts again, right? Review the witness statements, review it all anew. And he said I had the right to have that, my termination and the hearing all reviewed on new facts. He also, around the facts that existed, but, you know, reviewing not just for law, but for the factual questions. He also said because and I couldn't find this necessarily in here, what he said specifically. I'm not saying I looked as hard as I probably could have, but he said that the administrative law judge did not permit the introduction of evidence. I presume he means of certain evidence, not all evidence. That would be hard to imagine.
I think there's and I think it'll help the listener to understand what's happening here. And every department has a slightly different procedure, or maybe not every department, but different parts of the country have different procedures for dealing with discipline. And in this one, the firefighter was charged with violating the rules. The fire chief found him guilty. Okay. And the official term for that is the charges were sustained. Right. The firefighter then has the option to appeal. And then it goes before an administrative law judge. And there's a question about whether or not you get a de novo review at that level, or whether basically the administrative law judge just makes sure that the chief has enough evidence. Okay, so there's a question here. Now, the chief held a hearing and there was evidence admitted, but the firefighter was alleging that there was evidence that came in that should not have been considered. And I don't know if you were going to speak to that part of it.
A little bit, yes, definitely.
Yeah, so I think but we got to understand. And then, so typically you have the department level, then you have the administrative law judge appeals level. In some states, it could be a civil service commission. In some jurisdictions, it could be a collective bargaining grievance that goes to an arbitrator. But you have the department position, you have the appellate, administrative appellate, and then from there, there's an appeal to court. So we're dealing now with the court's interpretation of what happened 1 to 2 levels below in the process.
And one of the interesting claims, just to kind of finish rounding out his claims, is he said that the ALJ applied the incorrect standard. I didn't see whether they use, preponderance of the evidence or substantial evidence. But there are, in other words, to our listeners, it matters what the burden of proof, or the standard for the burden of proof is, matters heavily, because it's harder in some states. I assume clearly here, he's arguing that the burden of proof they required, that the administrative law judge required, was too high. In other words, it was too hard for him to win. Is that a simple way to say it? Because he had to prove too much. Sometimes you only have to prove that, it's 1% more than 50% of the evidence was in your favor. Sometimes you have to prove that, look, the evidence could go in either way, but I met enough where it could be found in my favor. So I don't recall or know what burden they used, but obviously it was a higher burden than he would have wanted.
And I think you also have this issue. This comes up a lot when, again, I a lot of times I do this out on a timeline and it makes more sense. But if we think about it vertically, you have the fire chief's decision, and the fire chief, obviously, the department has the burden to prove a rule violation. Okay. Then you go to the appellate level. And the appellate level, the question is, who has the burden of proof? Does the city have the burden of proof to prove its case a second time? Or does the firefighter have to show that there was not sufficient evidence of the rule violation? So you have that sort of question. And the complaint doesn't really get into that, but it's just so that people can sort of follow the issues. There's a lot of factual issues here.
Yeah. And, what's interesting, people should understand, because I have this a lot and I say it to my clients a lot. You may recall about 2 months ago, 3 months ago, we won a case in New York where I successfully argued that the fire department didn't provide the firefighter with the proper due process. They then conducted an investigation, and now they've charged him again, and now we're going to go to a hearing, right? So effectively, you better know before you go back, before you even start the whole appeal, even if you get a fair hearing, what are your chances of winning? Right? Because here, under this state's firefighter Bill of Rights, now look, there are fines and penalties and preclusion, and I mean, they could kill the whole disciplinary process if they want, but they got to find malicious intent, that's a huge burden. So most likely what happens, even if they find a procedural violation, is it goes back it gets remanded and says, okay, do it over. Sometimes what courts will do is say, yes, let's take the burden of proof. Yes, they use the wrong burden of proof at one of the levels, but having applied the correct version, the proper result was still obtained. So there's a lot of ways to go. And one of the things that lawyers try to do is sway the judges by their version of the facts. Had we gotten a fair hearing, you would have seen how amazing this firefighter was and how great and important he is, all these things. So there's a lot of ways these can go, but rarely are you getting a preclusion to, hey, you're not even trying this again.
Yeah. Well, in this case, I think at the heart of his argument is that part of the reason he was fired was due to things that had happened previously, and that the city had not followed the proper procedure in documenting those defects in his performance. So essentially, under California Bill of Rights, in addition to due process,
60 days or something.
Before something can go in someone's personnel file,
right,
the firefighter, under state law in California, the firefighter needs to be presented with it and then sign it, or refuse to sign it and then it's witnessed. But you can't put something negative in an employee's firefighter's personnel file without the firefighter being aware of it. What the firefighter is alleging is that both the chief's hearing and the appellate hearing, neither one of them was the information excluded like it should have been. That this information should not have come in and should not have been used against them in his disciplinary proceeding. And that raises both a violation of the firefighter Bill of Rights, but also possibly a constitutional due process. So again, this is just the allegations. I kind of find it hard to believe a department like San Francisco would swing and miss at something like this. But who knows?
And it's interesting. New York State, for example, because this issue comes up a lot. I don't like any ability to put something into somebody's personnel file unless it has an expiration, right? Mm-hmm. 6 months later, right? So just for our listeners, what I personally find acceptable, if you're not going to give a hearing, right? If you want to give a written warning or a verbal warning, you either give a hearing, which you're not going to do on a verbal or a counseling, right? But it needs to come out of your file at some point. And if within that time, 6 months, a year, probably no longer than a year, in my opinion, but if it doesn't come out, if something else happens in that time, fine, we'll try both cases. But that's the problem that I find constantly, is that especially in New York State, and New York State, interestingly, is split. I am waiting very dearly to get a case because I think I'll take it all the way to the state's highest court. New York State is split on, you can stick something in their file, no big deal, even if it's permanent without a hearing. And that's horrible because now you're coming into your first violation you get a hearing on, and all of a sudden you've got 3 things in your past, which you can't even defend. They just introduce your record, right? And I find it incredibly unfair.
Well, due process requires that they have notice, so not necessarily hearing, but at least be informed of what they're accused of having done wrong and given an opportunity to explain or rebut. That's
and I think if you could put the rebuttal in the file, fine.
Yeah, absolutely.
But you can't use it as even some evidence against you if you haven't had the chance to defend it before a hearing. And I get the employer side too, right? What are we going to give him hearing every time we give a verbal warning? But a verbal warning always becomes a written warning because you put it in the file in writing. So I don't know. Anyway, it's great questions and a good case for it. Okay. Next, let's head to Cleveland. Cleveland is also an interesting issue, but not so complicated. So we have a battalion chief. This is a settlement. This is a settlement.
But this is a big case, Brad. This case goes back. I've been following this case back for like 10 years. It's really? Oh man, this is tied to some problems that Chief Darrell McGinnis had that led to a bunch of discipline against some instructors at the fire academy, and it's boy, somebody could write a book on this one. It's an interesting case.
And the part I pick up on is kind of, here's the question I pick up on for this case. Let me give the quick facts, very quick facts, and I'll tell you the question I pick up on. So we have a former Cleveland battalion chief. He claims he was retaliated against, and let me not emphasize this, based on a mistaken belief. he claims he was retaliated against based on the mistaken belief, not the actual fact, but the city believed he leaked information to a reporter in 2013 about Chief McGinnis's alleged, right, but lack of training.
Yeah, he didn't have enough hours. I think he was supposed to have 30. I forget. He was supposed to have 30 hours. He only had 10 or something. He didn't have all the hours that he needed to have. That's
okay. And I want to focus on that when we get to the First Amendment portion of this. Now, again, this is a settlement. This is done, right? But and I'll explain how we got there. But the underlying issue is really very, as you were saying, is really very interesting. So he claims he was passed over for promotion, retaliated against. What happens is procedurally, he files a suit in 16, alleged a violation of First Amendment rights, which is what I want to talk about, retaliation, false light, invasion of privacy, and that is not a term you see often. That is as unique as can be. We can talk about that. Intimidation, hindering public servants under state law. I mean, really uncommon allegations. But in any event, what happens is it gets to a federal appeals court, the Sixth Circuit, also a very smart court, and they allowed the suit to proceed to trial, and then they settled, right? As you say, paving the way for settlement. You know, obviously way more having followed this, but I just want to say, again, you know, just highlight on this mistaken belief. First, the First Amendment protects you whether you said something or whether you're accused of saying something, but you don't normally see well, we thought you said it, but you didn't. But I would say, and I always use this example when I lecture on First Amendment and Pickering and, you know, free speech, but it is a matter of public concern. Had he said it in actuality, it would be, in my opinion, and I want to know yours, obviously, but it would be, in my opinion, the fire chief's lack of training is a matter of public concern, clearly, at least to me, however a jury comes out. And if you made a comment about it, it would be protected speech.
Well, you know, if you did it as a private citizen, it would be protected speech.
Right.
If you did it as the chief of training,
that's the gist, because it fell within his employment duties. But right. You're right, and this is where the facts get so roll of the dice, because let's say it goes to court, right? And the court says, okay, but you were speaking as an employee, so it's not protected. And he said, yeah, but my job, the purpose of my job of training is to make sure both the firefighters and the community are safe. And that's a public interest role that goes beyond just an employment issue. I mean, I think I'd be arguing.
And that's why we have whistleblower laws, because if the First Amendment went as far as it suggests, we wouldn't need whistleblower laws. But the reality is it doesn't. And whistleblower laws are designed to protect someone who probably wouldn't get First Amendment protection because they're doing it in their capacity as an employee. So I think that, you know, he would be four square on a whistleblower protection. I think it's a stretch on First Amendment, but again, you know, who knows how the attorneys are going to be able to fashion their arguments and convince the court anyway, you know, that there should be some protection. Yeah.
Clearly, and they both found that something was a tough enough issue on either side that they settled. Now, you don't always know what settlement means. In this case, you know, $900,000 was that his actual damages? If that was his actual, hey, that's a straight out victory. But, you know, I didn't look to see what his real damages are.
Well, it'd be hard to say, because if you're a battalion chief in a big city like Cleveland, but you're on a track to become the chief of department, what's the economic harm at you being stifled at the battalion chief level, not going to deputy and on up?
Right. Over 5 years, you know,
so it's hard to, and also I think his career was cut short in that he ended up leaving because they were, according to him, they were finding excuses to write him up on things, which is all like a precursor to, you know, somebody getting terminated. So he felt like he needed to pull the ripcord and eject.
Right. And here's one of those cases where, when you've been accused publicly of maligning your chief, you're going to have a real tough time getting a new job somewhere.
Yeah.
right? You're
Yep.
not a team. You're allegedly not a team player. So
Yeah, so that it's tough. It's tough, and he took a position that he was not going to take this lying down. And I respect people that are willing to do that. Not everybody's willing to fight it tooth and nail, but he did. But certainly, you're right. It does certainly affect your job prospects going forward.
But in this case, I would have fought it if I was him, right? And I didn't really say that. I would want to make clear I didn't say that. So but in any event, let's do a really, really quick one because I want to get to the theft one, again.
Yeah.
But just as a note, I guess, unless there's more to it, San Diego now, and we've seen this where now municipalities are saying, hey, you polluted our groundwater, so they're suing the AFFF manufacturers, naming public or alleging causes of action for public nuisance, that you have to abate it, the nuisance,
trespass,
damage, defective design, you failed to warn, trespass, negligence, all this stuff. So this just jumps on the piggybacks all the thousands of other suits.
Massachusetts just filed last week. I saw a headline. Massachusetts joined in that litigation on the AFFF. And for those who aren't familiar with it, I mean, we're seeing lawsuits from municipalities. We're seeing it from states. We're seeing it from individual firefighters who've developed cancer. There's certain cancers that are associated with the byproducts. They call them forever chemicals, but they just get in the groundwater. And I recall in Providence, we were told that AFFF is like soap. It's really no worse than soap. And if you had some leftover 10, 12 years old that hadn't been used, we'd use it to wash the floor. I remember as a chauffeur, we had a AFFF tank in the truck. You'd stick your fingers in it to, because it's kind of way in a compartment. You reach in, stick your fingers in it, and say, oh, we got enough, or no, I've got to, again, we were just given a lot of bad information about that. We used to
spray people with it for fun. I mean, you put it in a fog nozzle, you can create a whole bunch of fuzzy bubbles. I mean, we have, I probably have pictures if I looked hard enough. I probably could find pictures on some old, cameras of just swimming, basically being covered in it. It's just not, it's foam. Anyway. Okay, so that's that, and I always worry how many of these manufacturers are just going to declare bankruptcy. But some of them are so big, I think.
Well, the suits have all been, again, for those who aren't familiar with it, all of the suits have been sort of brought to the U.S. District Court in South Carolina. I don't know if they're a particularly slow court, or they drew the short straw, but the bottom line is these cases now get referred down there. And then that way the court gets a little bit of an aptitude and understanding of the issues. And it's the sense is that they're better able to handle that.
And I'm sure they tried to forum shop it. Same thing happened with all the COVID, vaccination cases and such. They all send them to one circuit, for the court's expertise. This is where we finish up. I hate doing this on Memorial Day, but man, just one more time. Now we're at and I really want to get into the specifics, so I'm going to. But a former Detroit Firefighters Union treasurer got away with, didn't get away, but stole $200,000. But and she did it between, I think, 16 and 19 or 2015 and 19. But I want to talk, and you do a great job in the blog about, highlighting what she did. But I want to talk about each of those because, again, my saying, but the person you trust is always the person who steals from you. And if you treat them like you trust them, they're going to find a way to steal from you. If you really value your treasurer and you really trust your treasurer, treat them like you don't trust them. Right? Audit them, and
that's hard. So, that's hard because we want to go in the opposite. I agree. I agree 100%. But saying it and doing it,
I know, but this is when somebody steals from you, it's your fault. I'm being harsh, but that's my belief. If somebody is allowed to steal from you, there's no new ways of stealing. I follow every one of them. I've got a long list of them. How people steal. Nothing in this list was not in my list. There was nothing new here. Everything I've seen. But let's talk about it anyway one more time. This is one of 50 different ways people steal from you. It's like 50 ways to leave your lover. This is 50 ways to lose your money. So
Sounds like
here,
a new program.
yeah, I think right. I think we're gonna do it. I think we're gonna do it. We'll come up with a song. In any event, so she takes $167, almost $168,000 in different things. So I'm gonna go slowly in them. First, she issues checks in her name and then changes the name of the payee in the QuickBooks software. So if you believe that a financial report is reliable, then I can make you a billionaire in a heartbeat, right? Because I can put any number in QuickBooks or any other financial accounting software you want. So if your audit is limited to reviewing your general ledger or your profit and loss statement or your balance statement, and you're not actually reconciling with and you can reconcile with the bank statement all you want, right? That's not going to catch it. The failure here, and I swear I've been lecturing on this, easily 15 to 17 years. The failure here is to review the checks that were actually returned after being cashed. Let me be so emphatic to everybody listening. If you do not review the actual checks and the actual deposit slips, the actual anything that happens after the transaction, you are going to lose your money. There is nothing that happens before the check or the money is cashed or transferred, whatever, that is reliable as an audit tool. You have to look after the fact. Had the union had an auditing committee, which everybody should have, and on the auditing committee is people without any beneficiary authority, right? They can't write checks, they can't be paid, anything. So they audit, but what they audit is what comes back from the bank, right? The cashed check. And had they done that, they would have found this. None of this was hard to find. You just have to look. Okay, the second one, and cut me off anytime you want.
Oh, go for it.
Okay, the second one, she cashed checks which were voided by her in QuickBooks. So it says void, right? So, but she actually cashed the checks. What this tells me is they weren't even reconciling the bank statements with the QuickBooks account, because if you void a check, then you've somehow got to come up with, okay, what happened to the money? So what happened to the money? Well, a reconciled statement would show that. And I got to tell you, our law firm is doing a ton of these. We call them financial reviews. We can't use the term audit because we're not CPAs, but we're doing a check, by withdrawal, by transfer. You know, we look at everything. And if you look at everything, they won't get around it. Okay, so here I know you're not even looking at the reconciliation statement, and I find that's extremely common. Disturbing, but extremely common. Okay, then she wrote checks payable to cash. Okay, your first line in your procurement policy is no checks ever will be made to cash, period. End of story, no further comment. And finally, she withdrew cash from the bank accounts. Okay, same deal. Debit cards will never be allowed. On any credit card, you will not allow cash advances. End of story, end of comment, bad practice. Cash cannot be traced. You can't justify it, and you can bring back any other receipt you want to try to manufacture some, excuse for it. So those are the main ones, but she does more. She also diverted funds that were intended to be donated to the NAACP. So here's the thing, you've got to look at deposit slips. Now, the treasurer also should never be receiving money. Somebody else, and in the fire service, the volunteer fire service, we have an antiquated position that's still used today called the financial secretary. And that was a old time, I bet if we look back, probably back to the early 1900s, that was an old time position used to receive monies, audit the monies, account for the monies, and then give them to the treasurer for deposit. And I am all in favor of that. If there are a number of banks, if you do a fundraising campaign that you can have the money sent directly to the bank, they will deposit an account for you. But bad idea to have any treasurer receiving and accounting for donated funds. Next And again, this is all I say, shame on Detroit. And I'm not trying to pick on you, but there is nothing new here, right? Again, if I got stolen from, it would be my fault in this case. But so you also, credit card, she was using the union credit card as her own personal card while she was treasurer. And I just want to point something out. Not only was she using flights, hotel rooms, she took a cruise using the credit card, right? And that cruise was a substantial amount of money, almost $9,000. Had they looked at the credit card, I'm sure it would have stood out because it was Royal Caribbean. It would have popped out. So you're not even looking at the credit card expenses. What a lot of places do is they say, okay, the credit cards, here's the money to pay the credit card, but they never audit the receipts of the credit card. Detroit, call me up. I would love to work with you because I can come up with the right union practices for you, but you need an audit committee. And I'm telling you, it's not that hard to prevent theft, but it's so easy to allow it. And here's one last point I want to make about this. She's hired, and it's not even within a year that she starts stealing. So my question is, what was the background check on her, if any? Right? What guidance, what rules did we give her? Probably none on both ends.
She's probably elected. I mean, she's the elected treasurer. So I don't know of any. I don't know of any union that does a background check on their elected officials. You assume especially in a big local like that, you expect the process.
I'll tell you where the background check comes in. Yeah. If they're going to be bonded, and it doesn't look like she was, it doesn't look like they bonded the treasurer because
I wonder how many unions do bond there.
Oh, you're nuts if you don't bond. Listen, my rule of thumb for bonding, and then I'll tell you how I got to the background check. So they probably, I know emphatically they didn't bond for it because you also note in your blog that they commenced a lawsuit for 4 times the amount. All right. And so they're suing her. They wouldn't have needed to do that. They would have what's called subrogated the claim to the insurance company. In other words, the insurance company would have sued after they paid the union back the actual money and the $220,000 with interest. So I don't think they were bonded. If you bond, not every, but many insurance companies will want to run a background check on the treasurer. The treasurer has to consent. So fine, you elect them, but you should have a bond. The bond should be for 1/3 of the money you take in. You don't have to spend, I shouldn't say nobody. Most places aren't going to steal 100% of your money. They're going to steal 10, 20, 30% of your money. So to me, at a minimum, if you can't afford more, bond for 1/3 of your account balance over a year. And they must not have done that. There was probably no bond because most likely there would have been a background check. And even when I write treasurer requirements, I always write, you must be able to qualify for a bond to be elected or installed. And you got to. Now, one problem is, and the insurance companies are being pretty good, at least the fire ones, ESIP, VFIS, Utica National, they're being pretty good about not invoking something which they could, which is the knew or should have known. If an insurance company, many of them reserve the right in their bonds, right? Their fidelity bonds, what they're called, trust and loyalty bonds, a lot of bonds, but they're fidelity bonds. The insurance companies usually reserve that if the employer or the union, the insured, knew or should have known, and then the phrase I just saw, could have known. And the could have is a very broad phrase, which says if you didn't audit, if you just turned a blind eye and gave 100% of the trust, the insurance company can deny you the claim because you didn't even make a good faith effort to look, which, look, I'm not trying to beat up Detroit. Detroit, has so many other issues, right? With equipment and financing and everything's burning to hell and, and great movies burnt and all that. But I feel for Detroit. I'm not trying to pick on them. They are just one in, how many
this could happen to anywhere, anywhere where the union does not have the right controls in place, the right financial controls in place.
Right. But enough's enough. Now you got to have them. And frankly, if they were audited, and which I suspect there was not even an audit of the union, they would have caught this in their internal review of financial controls. And if you do a financial review, which we do a lot of, or an audit, which CPAs do, one of the first things they evaluate are internal controls. And they would have said, looked and seen all of this. None of this was hard to prevent. Look, hopefully they get the money back, and lesson learned, hopefully they put in good procedures. Again, Detroit, I'm here for you. I'd love to do this, but we, how many times, Curt, have you, me, separately together, lectured on these things? This is not new. This is just, look, we trust you, brother and sister, with our life. You would, die to save me. So clearly you would never steal from me. I get it, but just stop it. There are crooks in every industry. And that's Memorial Day.
Yeah. And, we got a couple more in Beyond the Blog. You could take a look at them, but we got a suit in Danbury. I believe that's Danbury Township, Ohio. No, Danbury Township, Ohio. Yeah.
Oh, okay.
Oh, yeah. A little sneaky there. And then, let's see. We've got a West Palm Beach, got a stretcher flip. I actually have a category in my database now, stretcher flips.
I'd love
stretcher
to see
drops. I got stretcher drops, and I got stretcher tips. And so we've got
they're
one
overweighted on the wrong sides. I mean, we're doing some of that. It's weird. I saw a manufacturer I got to look at, but not to get too off on that. But we used to hang things on the underside on the let's say the head end of the stretcher. But what happens a lot now, especially, and I don't know if the ones I'm seeing are these like intra-hospital transfers, and they're side loading the I call the cabinet side, the patient's right side of the stretcher, with all these micro drips and everything. And it's creating a very hard balancing issue for EMTs and paramedics.
Wow.
So,
we're seeing them. We got the mass case with the AFFF, procedural bylaws lawsuit in a fire district. Couple of paramedics in South Carolina sued for wrongful death, and some more headaches coming out of San Francisco on drunken firefighters. So, but that's going to do it for another edition of Fire Law Roundup. We'll see you again next week.